A 20-year-old woman started using YouTube when she was 6 and began using Instagram when she was 9. She is now suing both companies, and her case is about to be the most important tech trial since the DOJ took on Microsoft in 1998. It's arguably the most important trial around human behavior since the big tobacco trials. Here is what's at stake and why you should care about it, whether you are a parent or not. I'm Jake Ward. This is The Rip Current. We look at the big invisible forces shaping our lives. And in this case, the plaintiff, who's known publicly as Kaylee, or by her initials, KGM, and her mother allege that Meta and YouTube have deliberately designed features that addicted her as a child and led to anxiety, depression, body dysmorphia, a whole host of ills in her life, including suicidal thoughts. Now, she began using YouTube at age 6 and Instagram at age 9. And today, right, in today's climate, you could look around and sort of say to yourself, wow, really? Like that's doesn't seem like the move, right? But you have to remember the time that she was growing up in, a time when social media was seen as really nothing more than a positive way of connecting people with their interests and with other people like them, right? So her case is a bellwether, right? It is a legal test case for what is about to be more than 1,500 other similar lawsuits that are waiting in the pipeline. Now, Snap, the maker of Snapchat, and TikTok, they both settled before the trial, but Meta and YouTube have decided that they are going to go all the way. They're going to take this to trial. And as a result, juries are going to be hearing from, in this case, the CEOs of these companies. Adam Mosseri has already testified. Mark Zuckerberg is about to testify this week. Neil Mohan, the head of YouTube, could be called soon enough. And that, putting those guys in front of juries is a very new thing. We've seen them in front of senators and subcommittees all the time, but getting them in front of a jury of everyday people who are going to judge them on their credibility and judge whether these companies knew something bad could happen to kids and did it anyway, that's a totally new thing. So the plaintiff's lawyer, KGM's lawyer, Mark Lanier, he opened up with this thing of laying out the ABCs, which what he said stood for addicting the brains of children. He called Meta and YouTube, quote, two of the richest corporations in history who have engineered addiction in children's brains. And he explicitly compared them to big tobacco. And the tobacco parallel invokes a lot, right? We can have a good faith argument about whether the addiction to tobacco and the quote unquote addiction to social media are in any way physiologically or psychologically related. But what this is really, where the comparison actually holds is in the idea that both industries may have had internal documents showing that executives knew about harm and chose to grow the business through selling the product anyway. The difference here is, of course, tobacco sold a physical product that was shown to have full-on physiologically addictive capacity and wound up causing lung cancer in people, right? These companies sold attention. And their argument is that attention is not a product, right? And it's just what happens when you make something people like, that they say we are being picked on because we are victims of our own success. So the difficulty for their argument in that case is how many internal documents are already coming to light. The discovery that comes up in this trial where these pieces of evidence are turned over and we get to, for the first time, see how these companies were actually looking at the world internally, as evidenced in how they spoke to one another as executives, and as evidenced in the pitch decks that circulated and in the internal research that they were doing. It gives us a window into how these companies were making decisions and the shorthand ways that they were talking about the risks associated with those decisions, which is pretty incredible. So YouTube had internal memos which described the goal as viewer addiction, likened the platform to a casino. Meta had something called Project Mist, which was an internal study of about 1,000 teenagers, and found that kids who experienced trauma were especially vulnerable to addiction, and that parental controls made almost no difference in those cases. And they sat on that. That was not publicly released, right? A Meta document also identified tweens, ages 10 to 12, as especially valuable because they were more likely to stay on the platform long term. And Mark Zuckerberg is cited as having felt that teens teens would be the priority for them in at least one quarter of 2017. There was another document inside where they said that our pipeline for teens begins with getting tweens on the platform. So a clear sense that they were creating a pipeline over time of kids to get them onto the platforms. And only a tiny fraction of young Instagram users were enrolled in the parental oversight tool that is currently available as of March 2025, a tool that they've made a lot of noise about. And it's the thing that they keep pointing to as evidence of responsibility. So what hangs in the balance here is what's called Section 230 of the Communications Decency Act, this Telecommunications Act from 1996, which has been the tech industry's kind of blanket immunity for nearly 30 years. It basically says that you cannot sue a platform for content that the users post, okay? And it is the basis of the modern free internet, free and open, marketplace of ideas, as its boosters will call it. This idea that unlike a publisher, you're not legally responsible for what appears under your name. You're only there to provide the infrastructure by which it gets out into the world. But the plaintiff's argument here, and this is a plaintiff that the judge in this case has said the jury is allowed to consider, is that this trial is not about content, it's about design. It's about infinite scroll and autoplay and the like button and all of the ways in which this company built systems by which content was surfaced and shown to you and pushed on you in some cases. These are, according to the plaintiff, right, these are engineering choices. They aren't just, this is the truth of the matter. They're engineering choices. They're not just posts. That's what they're saying was the problem. And if this argument wins, it doesn't just affect Meta and YouTube. It potentially exposes the design decisions of every major platform to a liability claim, which is a very new thing and very important to understand. So one of the sort of most dramatic facets of this case is that parents have flown in from all over the country to watch Zuckerberg testify, which he is going to do this week. One of them, Joanne Bogart of Indiana, lost her 15-year-old son Mason in 2019. He died attempting something called the choking challenge, which she says he discovered on YouTube. Her lawsuit was dismissed on those Section 230 grounds, that content was not YouTube's responsibility. But she's there anyway, and she's saying, she told CNN, "We are all doing our best as parents, but we are fighting these trillion-dollar companies." Now, the lawyers, at least in Meta's case, who we've heard from so far, say that this hinges on the question of what role, this is how they put it, what role Instagram and Facebook may have played in her ongoing, this is KMG's, ongoing mental health struggles. So what they're trying to say essentially is that this kid had pre-existing mental health problems that that they are simply that her experience online was simply a reflection of, right? And so this idea that, she had anxiety and depression, body dysmorphia, and suicidal thoughts, they're saying that probably was just part of who she was and of the circumstances that she was in. They're blaming the kid and blaming the parents. And the reason that fighting back against this is such an important thing in this case is that, right, this is a kid who didn't just passively consume it. She, early in her life, had posted hundreds of videos to YouTube, which, if the jury finds for the plaintiffs, really pierces an argument that these platforms have made for a long time, which is that the participating as a creator is a very positive, mentally healthy, positive thing. So there are there's so many things sort of at stake in how we have understood all of this stuff, especially as these companies have sort of spun it. And so, the thing I sort of keep coming back to here, right, is that we don't get a lot of democratic inputs into these companies, right? They make choices based on their ideas about market fit, on their finding out what, works and what doesn't, and the ways in which they make money and they don't. There isn't a lot of democratic input. And so I've argued for a long time that courtroom cases like this are really the only kind of democratic input that we're going to have when it comes to how these companies function. And this is the first one of those, which is why I'm following it so closely. So, right, this idea that nobody voted on infinite scroll, right? Nobody voted on autoplay or like buttons. No regulators approved any of those things, right? And a small number of engineers and product people and the executives they worked for greenlit this stuff. And billions of people, including in this case 6-year-olds, inherited the results, right? And so that is the central argument of the book I made, which is that the book I wrote, The Loop, how I called it at one point How Technology is Creating a World Without Choice and How to Fight Back. The paperback is called How AI is Creating a World Without Choice and How to Fight Back. But over and over again, what I keep returning to is that the incentive structure of these companies and the technologies that they make possible around shaping human behavior are having an enormous effect on all of us. And the normal democratic inputs that we would expect in a case like this do not apply. And so the fact that a Los Angeles jury is being asked to weigh in on these questions right now is a really big deal. And so the trial is expected to run 6 to 8 weeks. I'll be covering it throughout, and I hope you keep up with me here as we do so. Thanks. The Rip Current is produced and created by me, Jacob Ward. And if you liked this show and you want more content like this, go to theripcurrent.com, where I publish a weekly newsletter that covers these same sorts of stories of the big invisible forces that have us all in their grip. And if you want to really do me a favor, if you could go to where you have listened to this or watched it and like it, share it, or even better, review it. Holy cow, is that helpful? It's the best possible way for me to find a new audience. I really appreciate you being here. Thanks for listening.